my name is Hewot Shankute, and I'm a staff attorney and clinical supervisor at the East Bay Community Law Center located in Berkeley, California. I work in our Community Economic Justice Clinic, also known as CEJ, one of EBCLC's 8 community-based clinics. CEJ's mission is to advance people-oriented economic development and empower low-income communities of color to build long-term solutions to poverty in the East Bay using an anti-displacement and racial justice framework. Our clients are primarily nonprofits and small business owners, also self-employed individuals who have been hit hardest by the COVID-19 pandemic. We've prepared presentations and other resources on our webpage to help equip our impacted clients and communities legal information to help weather this public health and economic crisis and to prepare for what's to come after. And before we begin, we ask viewers to pause and please read this disclaimer. We emphasize that none of the presentation information constitutes legal or financial advice, so you should contact an attorney or tax professional for such services. So today we're speaking to impacted businesses, small businesses, and nonprofits who are commercial tenants. And the purpose of this presentation is to equip commercial tenants with some legal information. It does not explore the full range of potential legal issues facing commercial tenants, but rather offers some key considerations. The last slide offers additional resources for further legal assistance on your specific issues. There are a number of emergency government orders relating to temporary eviction protections, which may offer you some legal relief depending on your situation. However, this presentation will not address the specific eviction moratorium, so we encourage you to check your county and city government web pages for the most current commercial eviction protections and the specific tenant qualification requirements. Note that while several government orders might provide some temporary commercial eviction protections and potential deferment of rent payments, these protections don't amount to complete rent forgiveness. That said, even if eviction moratorium protections aren't available to you, tenants and landlords still have the opportunity to respond in different creative ways through open dialogue and negotiations. And that's the purpose of this presentation, to help empower you with some legal information strategies to better navigate that process. So unfortunately, under California law, commercial tenants have less statutory rights and protections than residential tenants. Many residential protections like good cause evictions, a warranty of habitability, or a landlord's duty to mitigate losses does not apply to commercial tenants. That's why your written lease is so important, because it contains your specific legal rights and obligations. Your lease is the contract, by definition, is the contract between you and the landlord for the rental of certain space located on the property. So reviewing the specific language under your lease is the first step in identifying any potential legal relief. In the next slide, we'll address key considerations to keep in mind when reviewing your lease. First, we'll discuss the significance of identifying your landlord, and then flag some key lease clauses which might offer you some contractual relief if available in your lease. Again, this is a limited presentation where we're only covering some general considerations. So please consult an attorney to review your lease and fully evaluate your specific situation and range of legal options. So the more information and support you have going into negotiations with your landlord, the greater leverage you build. I think most of us know that. So if you don't know already, identify who your landlord is under the lease to consider the different motivations they have for owning the commercial property. And remember, there's always strength in numbers, so speak with other tenants to consider approaching your landlord collectively to address your common issues if you have them. And if there are other tenants in the building, that's one sure way to build leverage. Let's briefly address individual owners, commonly known as mom and pop landlords, investment group known as flippers, real estate developers, and institutional owners. So generally speaking, individual landlords hold smaller portfolios where the commercial property they might be renting to you is their primary long-term investment. Individual owners tend to be more reasonable and easier to work with. Their main motivation is maintaining steady, reliable rental income. So they might work with you on a longer term to reduce your rent if the rate sufficiently covers their expenses. Now, unlike individual owners, investor landlords hold multiple properties for short-term speculative purposes, and so they might be less reasonable. Investor landlords' main motivation is ensuring a highly profitable short-term resale of the property. So maintaining higher leasing rates means that they can resell the commercial property at a premium. So it might help to show your ability to contribute ongoing marketability or to extend lease terms at a rental rate that's acceptable to you. Real estate developers acquire and develop office, hotel, retail, and mixed-use properties. Now, these buildings typically have premium amenities. They're looking to generate the highest amount of rent possible in order to maximize their property value. So, but in these times, rather, you might have some openings to trade reduced rent for a long-term lease, especially if reduced demand for rental space persists. Institutional owners are institutions like pension hedge funds, banks, and endowments. Might be looking for long-term, steady annual returns. There might be some receptivity to work out long-term repayment plans. That means the landlord can stabilize ongoing long-term rental payments and tenancies. Again, these are just some general considerations worth keeping in mind as you deal with your specific landlords. So also utilizing the business entity search feature on the California Secretary of State's website, you can Google it, might provide you more information if your landlord is a legal entity and not an individual owner, that is. As mentioned earlier, the point here really is just to increase your negotiating leverage, and always remember the value of knowing the fellow tenants in your building. A little animation there, if any. So you can unite on shared challenges and really organize collectively on resolving your common issues. Okay, so we're going to transition to identifying key commercial lease protections, which may offer you some contractual relief. Few leases are likely to include specific provisions regarding pandemics of this type, but you may have negotiated other helpful provisions. This isn't an exhaustive list, so we encourage you to obtain legal counsel again for further review of your lease. Let's go over each in the next slide. So the rent clause. Locate your rent clause to determine your payment obligations. Most leases make the payment of rent an independent obligation that is not tied to any closing of the premises or reduction in services provided by the landlord. However, you may have negotiated for a rent payment, also known as a reduction in rent, in certain circumstances, such as if the building the premises is located in closes or the landlord cannot provide essential services. If you identify a rent abatement provision, confirm the conditions that apply and the specific noticing and time periods to activate the abatement rights to reduce your rent payment obligations. Next, the security deposit provision. Look to see confirm the specific amount of any security deposit you paid and the form of security deposit, whether it was a cash deposit, a check, or a letter of credit. Spot any notice requirements the landlord must provide you before offsetting the security deposit against past due rent. Force majeure. Now, this is an interesting one. Most leases contain what's known as a force majeure clause for unforeseen events. What it is a clause that justifies a party's non-performance of an obligation, potentially including rent payment, under the lease because of an unanticipated event beyond the control of the party. Some examples include natural disasters, war, strikes, pandemics, or government actions, including state-imposed shelter-in-place orders. Force majeures have become an increasingly important provision because of the pandemic. It's a very high standard that's traditionally been read narrowly by courts and businesses, and often includes specific exclusions for excusing rent payments. However, there's much legal debate on this clause, and we anticipate increasing litigation over its application to the COVID reality. So it doesn't hurt to locate the specific provision if you have it, see what legal arguments could afford you any potential contractual rent relief. Contracts with the more explicit language about epidemics and government actions will have likely more success in withdrawing obligations to pay rent. So you'll need to carefully review what constitutes a force majeure event under your specific lease to determine how it applies and what steps to take to properly utilize the provision, including prompt noticing requirements. Other legal doctrines like impossibility or frustration of purpose might also apply and might be worthwhile to explore your specific context with an attorney. All right, so your lease likely contains a variety of deadlines for performance or the exercise of rights or options. Identify any upcoming deadlines in your lease and understand potential implications if reduced staffing or closures might prevent you from meeting a specific deadline. Some common deadlines include lease expiration dates and termination noticing requirements, lease renewal and other option deadlines, including deadlines to calculate prevailing market rents for renewable options, tenant improvement allowance payment deadlines, and lastly, locate any audit right deadlines to enable you to audit the landlord's books and records to ensure the accuracy of any maintenance charges. Next, termination rights. So some tenants may have negotiated for a right to terminate the lease if gross sales fall below a certain threshold, which is particularly advantageous, especially right now. So if your lease contains this right, you must determine what notice and financial documents are to be provided to the landlord in order to exercise this right. So your lease may contain the right for you to terminate in other certain circumstances as well, so keep an eye out for that and any applicable qualifications to invoke those rights. Next are default cure rights. Let's say you have violated a term of the lease, such as failing to pay rent when it's due or signing the space without obtaining necessary consents. You may have negotiated a provision to cure that default, which allows you a process including some time to correct the violation and resume your legal compliance under the lease. Many leases require that tenants carry property insurance policies. It's pretty standard. So this might include commercial general liability, business interruption, or other insurance policies. We focus in on business interruption insurance because it covers financial losses. And so review all of your insurance policies to identify whether COVID-19 related losses are covered. In many cases, business interruption insurance typically requires physical property damage before a claim is made. So you should carefully review the terms of all policies and riders included. And given these unprecedented times, legislation may alter insurance company duties, and litigation may result in new possible claims being successful that would not have been granted prior to the current state of affairs. And we recommend tenants make pandemic claims under these policies as soon as possible to preserve payment rights. Lastly, landlord lien issues. This one isn't exactly a commercial lease issue, but it's still a key consideration. And it's whether the landlord has any lien rights on your personal property and equipment, and you'll want to identify and, if possible, lift any liens in case you need to sell this personal property and equipment quickly to generate cash flow. Now, let's say your lease doesn't offer you any specific legal relief from your obligations. The good news is that it's still in the best interest of both you and the landlord to work together to find a mutually beneficial and creative solution. Now, the type of solutions will depend on numerous factors, including the specific context of your lease, your established relationships and trust with the landlord, the specific, or rather the severity of the impact on the parties and available government relief, and of course market factors. So you should always communicate with your landlord in writing. If you're communicating verbally, follow up in writing to confirm shared understandings. Some talking points to include in a letter or any written communication to your landlord include acknowledging the global pandemic, mentioning how the current government orders are affecting your business, providing details about your inability to pay full rent, such as describing business closures, reduced hours of operations, reduced revenue, etc. Consider introducing the landlord to your unique business model, educate them on how your business operates, how much you were making before the pandemic, provide detailed steps that you've taken to mitigate impacts, and mention your plans to reopen as soon as possible, and describe reopening scenarios. If applicable, especially for smaller landlords, you might want to confirm your awareness of financial pain the landlord is experiencing and your willingness to advocate for government relief for both rent and mortgage freezes. Now, here are some tips for proactive rent repayment negotiations with your landlord. Again, be sure to consult with an attorney for further guidance as you and your landlord figure out workable solutions for addressing specific lease obligations, namely rental payments. So you can consider adjusting the terms of the lease either during the pandemic or permanently. You can offer to extend lease terms to make up for months with missed rent payments and adjust rental payments accordingly. You can take the route of suspending or modifying performance under the lease, such as postponing payment of rent due under a future mutually agreed upon date. Consider decreasing the percentage of rent due for 1 or more months where the landlord agrees to absorb the difference between full rent and decreased rent. Can look into offering to give the landlord a percentage of the net revenue, your net revenue after other expenses, instead of monthly kind of fixed rent due under the lease, and agree on a written payment plan for rent not paid immediately as scheduled under the lease. Now, in these next couple of slides, we want to offer additional avenues for commercial tenant relief, recognizing that these are more long-term solutions. Now, moving beyond the urgent legal relief possibly available under your lease and or through individual negotiations with your landlord, commercial tenants can come together to join efforts urging the governor and local officials and policymakers to institute equitable relief policies that adequately protect commercial tenants, small businesses, along with residential tenants during this pandemic. So we invite you to explore connecting with organizations like tenant and neighborhood councils and coalitions and campaigns like Housing Now and Homes for All to engage on conversations and organizing efforts around commercial rent cancellation and forgiveness. Another alternative strategy is exploring the potential of a collective purchase of your commercial space for the purpose of creating fixed affordability. Now, without a doubt, the idea of purchasing the commercial property you're renting might seem overwhelming from an individual standpoint, but these times of crisis call for us to rethink what is possible when we come together to address our common problems. So while acquiring commercial property alone might seem out of the question, perhaps there are other co-tenants with whom you could pool resources with to acquire the property collectively. And believe it or not, it is possible with the help of supportive community-based organizations like Community Land Trust or CLTs or permanent real estate cooperatives. CLTs and permanent real estate cooperatives exist to acquire community-serving real estate for the purpose of ensuring it remains affordable forever. They might be able to support you and fellow commercial tenants with acquiring a commercial property for the purpose of providing permanently affordable commercial rental spaces for the community. And so here are a list of some of our close partners who could help you explore what community control of commercial space might look like for you. As an example, we invite you to visit Oakland CLT's webpage to learn more about how residents partnered with CLTs recently to successfully acquire a mixed-use building in Oakland as a community asset with permanent affordability. All right, so that brings us to the end of this presentation. We understand this is a lot of information. We will upload additional resources on our webpage, including a sample letter to a landlord proposing rent repayment terms that you can modify according to your specific circumstances. Please contact us at EBCLC by emailing CEJ@ebclc.org. If you have any additional questions, we've also listed additional resources here. We hope you found this presentation useful, and yeah, we just thank you and take care. Check out our webpage.